What makes speech offensive? What makes it political? Historically speaking, it just depends on who has the power to decide.
In 1873, Postmaster General Anthony Comstock seizes any mail he feels is obscene, including sex toys, novels, even personal letters. Critics noted the arbitrary nature of the laws. At least one judge noticed the laws lacked any clear, broad, well-defined principle or purpose. Comstock went on to prosecute thousands of citizens under his ill-defined laws, including influential suffragist Victoria Woodhull.
At the beginning of the First World War, Charles Schenck is arrested in Philadelphia for circulating anti-draft leaflets.
Schenck, a socialist, opposes the military draft as well as the war itself. The leaflets describe the 13th Amendment of the U.S. Constitution, which prohibits involuntary servitude. The police declare the leaflet's content to be subversive. The government charges him under the Espionage Act. At the Supreme Court, his lawyers argued that the First Amendment guarantees the right of all Americans to voice political opinions, so long as it does not incite violence. His leaflets explicitly promote nonviolence in opposition to what would soon become regarded as a global tragedy. Because the U.S. was already at war, Justice Oliver Wendell Holmes compares Schenck's distribution of leaflets to yelling fire in a crowded theater. The 9 justices unanimously agree Schenck is jailed. Schenck is only one of many to be prosecuted for opposing U.S. involvement in the war. The Wilson administration viewed any opposition to the war as treasonous. Thousands of dissenters are jailed. In 1972, comedian George Carlin is arrested in Wisconsin for performing his routine, the 7 words you can never say on television. An off-duty police officer in the audience is offended. He heads to the nearest payphone, and soon police gather backstage. They declare his performance obscene. Carlin is promptly arrested when he leaves the stage. We've come a long way as a country regarding First Amendment rights. Comstock's laws were overturned, as was the Schenck decision. Carlin was later found not guilty, but the battle to protect our free speech rights from arbitrary and questionable government suppression is not over.
In 2010, poll workers in Minnesota prevent Andy Cilek from voting in a Gadsen flag Tea Party t-shirt, citing a law against wearing political clothing at the polls. Voters who wear clothing deemed political can be stopped from voting and could be fined $5,000. 9 other states carry similar laws, but the Minnesota law does not define what counts as political.
Poll workers have been given general rules of thumb, no specific candidates or policies. But this leaves open a concerning level of interpretation in an era where personal biases often bleed into public discourse. And even well-meaning poll workers make mistakes. In 2008, a Texas woman was blocked from voting for wearing a shirt that said Alaska. The poll worker believed this was electioneering for Sarah Palin. In 2012, a group of MIT students from Colorado were blocked from voting because the poll workers believed MIT meant Mitt Romney. The law is intended to protect citizens' right to vote without confusion, interference, or distraction.
Its supporters say it helps limit voter intimidation at the polls.
Does this shirt create confusion? Will wearing this interfere with others' ability to vote? Will this hat intimidate other voters?
Should you be blocked from voting unless you take this off?
Many state laws say yes. We say no. What will be considered political the next time you vote? How will poll workers decide what to allow? They will be forced to decide without any clear, broad, well-defined principle or purpose.
Pacific Legal Foundation is taking Andy Cilek's case to the Supreme Court to protect everyone's First Amendment rights.